Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. It is Friday, 23 January 2000, 26 years after Jesus. It is a Friday. Happy Friday to you. I'm going to share my screen. Feel free to call me Sharon. We're in Bostock versus Clayton County, Georgia. Bostock versus Clayton County, Georgia. And we're picking up where we left off, which is Alito's dissent. Now, you guys recall that, don't you recall that there was a split among Republicans on this case? It's 2020 U.S. Supreme Court. Gorsuch and Chief Justice Roberts are on the side of the Democrats. Hmm. And Alito, Thomas, um, and Kavanaugh are on the side of the Angels. I think Barrett was on. Barrett was not on the court at that time because this was the summer of 2020. We left off right at D1 in Alito's dissent, and I'm using the slip opinion today. I've been using the Google Scholar, which the pagination is messed up. The slip opinion is doesn't really have the final pagination yet because, I mean, it's not in the volume, and the volume is too expensive for me to buy right now. Google Scholar is supposed to track the volume, but the pagination's messed up on there. It's okay as far as it goes, but I'm trying the slip opinion today. You can cite it as 590 US and then a blank space 2020. Then you just put slip up, okay? And then Alito J dissenting, page 35 or at 35. The last thing we read was it defies belief to suggest that the public meaning of discrimination because of sex in 1964 encompassed discrimination on the basis of a concept that it was essentially unknown at the time. Yeah. And then D1. Now, what's this case about again? It's about the language of sex discrimination in the 1964 Civil Rights Act as it pertains to employment. And the Republicans on the dissent are correct. That's my correct opinion. Alito's doing a pretty dang good job. Kavanaugh takes another shot at it, as we'll see. We're going to finish Alito today. And this is explaining why the words sex discrimination do not reach the so-called transgender status that the Democrats want it to apply to today. So that if someone says, I'm a girl now, and they're not really a girl, they lie about it, or they're expressing a false belief because of some other problem, like a mental issue, mental problem, that somehow is not relevant to employment decisions. That's just false. And the Civil Rights Act does not pertain to those kind of employment decisions. So this is a big fight. Of course, this is a statute, and Congress did it, and Congress can undo it. And I think my interpretation of what the Republicans on the Democrat side were doing is they're not on the Democrat side for democratic reasons. They're on the Democrat side for separation of powers issues. They want to get Congress back in the game. And I think Roberts and Gorsuch were trying to kickstart this, giving Congress as much leeway in this language as possible, too much leeway, ironically, and in an effort to say, hey, if we got this wrong, Congress, you can fix it. So go ahead and fix it because we're not going to fix it. Whereas the dissenters are saying, no, it's the proper role of the court to correctly interpret statutes, and you'd incorrectly interpreted it. Now, yes, Congress can undo that, but You still have to interpret the statute correctly, and you got it wrong. The 1964 Act has nothing to do with transgender, so-called transgender status or homosexuality, which would be sexual orientation. So that's where we're at, and let's continue. And I want to point out that I don't know why I have to point this out, but I don't really have to, but I'm going to anyway. Look at the other episodes in this series on YouTube. They're on a playlist, on the gender playlist. They're also on the statutory construction playlist. So just go back through and or just go to the YouTube and search Bostock and you'll find all the episodes. Start at the first one. And if you want to learn it, you'll learn it. And if you don't, you don't. But here it is. D1, the court's main excuse for entirely ignoring the social context in which Title VII was enacted is that the meaning of Title VII's prohibition of discrimination because of sex is clear. Hmm. And therefore, it simply does not matter whether people in 1964 were smart enough to realize what its language means. According to the court, an argument that looks to societal norms of those times represents an impermissible attempt to displace the statutory language. The court's argument rests on a false premise. As already explained at length, the text of Title VII does not prohibit discrimination because of sexual orientation or gender identity. And what the public thought about those issues in 1964 is relevant and important, not because it provides a ground for departing from the statutory text, but because it helps to explain what the text was understood to mean when adopted. That is, it's an epistemological in our aid in our hermeneutics. Yeah. In arguing that we must put out of our minds what we know about the time when Title VII was enacted, the court relies on Justice Scalia's opinion for the court in Oncali versus Sundower Offshore Services. That would be 1998. But Oncali is nothing like these cases, and no one should be taken in by the majority's effort to enlist Justice Scalia in its updating project. The court's unanimous decision in Oncali was thoroughly unremarkable. Now, let me just get in here and refer to the last statement in that previous paragraph there. I will restate that statement there. But Oncali is nothing. Oncali is that Scalia opinion, 1998. Oncali is nothing like these cases, and no one should be taken in by the majority's effort to enlist Justice Scalia in its updating project. Okay, this language of its updating project, what does that refer to? Raise your hand. Yes, you in the back. Can you speak up? Uh-huh. Yes, it is a separation of powers issue. Yeah, that's right. What Alito is saying here is the court is overstepping its Article 3 judicial power and its duty. It's ignoring its judicial duty to stay in its lane. The court is impermissibly taking itself to update an old statute for Congress so that Congress doesn't have to get in the game, actually, ironically. So I want you to see this because I think what the Republicans are doing on the majority, the wrong side, the Democrat side, I think what the Republicans are doing there is they're trying to get Congress back in the game, to legislate, to clarify, to do a better job. Alito is saying they already did the job they did is already done, is fine. And you're trying to update. That's what the Democrats want to do. They want to update the statute to reflect the current times, quote unquote. And what times mean is they just mean like what the New York Times would think. That's what they mean by times. They don't mean what the average person would think. There's a very, it's kind of like a Hegelian thing. If you know Hegel, it's like a spiritual thing. The times, it's like the spirit of the times. Well, it's nebulous and it's almost impossible to define, except for if you hang out only with Democrats, whatever they would think seems to be what they mean by the times. It's really snotty and it's arrogant and it's narcissistic. Alito is having none of that crap. And he's like, no, we're not updating. That's not our job to update a statute. If it needs to be updated, Congress can do it. They're the ones that made the thing in the first place, for God's sake. Hello, hello. So this is a separation of powers issue here. But the dissent has a better argument here and is on firmer footing here. The court's unanimous decision in Oncology was thoroughly unremarkable. What I would suggest you do here is go get that and read it yourself. That's what I would do if I was in the law library. That's what I used to do. The court held that a male employee who alleged that he had been sexually harassed at work by other men stated a claim under Title VII. Although the impetus for Title VII's prohibition of sex discrimination was to protect women, anybody reading its terms would immediately appreciate that it applies equally to both sexes. And by the time Oncology reached the court, our precedent already established that sexual harassment may constitute sex discrimination within the meaning of Title VII. Given these premises, syllogistic reasoning dictated the holding. We're on page 37 of the slip opinion, Alito dissenting. Bostock versus Clayton County, Georgia, 590 U.S. blank, 2020. What today's decision latches onto are Oncology's comments about whether male on male sexual harassment was on Congress's mind when it enacted Title VII. The court in Oncology observed that this specific type of behavior was assuredly not the principal evil Congress was concerned with when it enacted Title VII, but it found that immaterial because statutory prohibitions often go beyond the principal evil to cover reasonably comparable evils, and it is ultimately the provisions of our laws rather than the principal concerns of our legislators by which we are governed. It takes considerable audacity to read these comments as committing the court to a position on deep philosophical questions about the meaning of language and their implications for interpretation of legal rules. These comments are better understood as stating mundane and uncontroversial truths. Who would argue that a statute applies only to the principal evils and not the lesser evils that fall within the plain scope of its terms? Would even the most ardent purposivists and fans of legislative history contend that congressional intent is restricted to Congress's principal concerns? All right. This is good. Well, let me pause it while I'm not going to pause it. I'm going to mute it while I get a drink of water. Properly understood, Oncology does not provide the slightest support for what the court has done today. For one thing, it would be a wild understatement to say that discrimination because of sexual orientation and I'm going to add so-called transgender status. I added the so-called because we already talked about that last time. You can Listen to that. Around minute, between minute 50 and the 1 hour mark last time, December 12th. You can listen to it, 2025. For one thing, it would be a wild understatement to say that discrimination because of sexual orientation and transgender status was not the principal evil on Congress's mind in 1964. Whether we'd like to admit it or not, in the thinking of Congress and the public at the time, such discrimination would not have been evil at all. Wow. Put that on a coffee mug. Now, he's not assuming relativism here. He's just the opposite. He's saying you want to get the correct you want to get the correct interpretation of the statute. It has a best meaning. It's not just any old meaning will do. And the best meaning is tied to what it was understood to do at the time it was adopted, publicly, publicly understood to do. It's like it's the originalism of public understanding tied to textualism, okay, of statutory construction here. Statutory construction, the text is evidence of what the law is. So who's right, they, them, or us on the actual evil? Well, that's not exactly the question. The question is, what does the text say? That's what the question is. So don't mistake this for an ethical argument. I think the Democrats are thinking this is an ethical debate and we're right, and because we're later, and this is like what C.S. Lewis calls the bigotry of presentism or some. He doesn't use that exact language, but it's like the bigotry of the present, always biased toward the present. Whatever is now is right, which is a bunch of baloney and a bunch of bullcrap. Uh, it just because you're later in time doesn't mean you're more progressed and righter. That doesn't follow at all. So, but that's really a different question. Who is actually right as far as the morality of it goes? I think a lot of Democrats don't even understand what you mean by that because they don't know how to think about morality in any kind of non-relativistic sense, non-Hegelian sense of right and wrong. They eschew eternal principles of right and wrong. That's why they tend to be secular. Secular doesn't like that as part of their worldview. But the more important difference between these cases and Ankali is that here the interpretation that the court adopts does not fall within the ordinary meaning of the statutory text as it would have been understood in 1964. To decide for the defendants in Ankali, it would have been necessary to carve out an exception to the statutory text. Here, no such surgery is at issue. That seems right to me. If you disagree, put it in the comments. I think this is a great argument. Even if we totally disregard the societal norms of 1964, the text of Title VII does not support the court's holding. And the reasoning of Ankali does not preclude or counsel against our taking those norms into account. They are relevant, not for the purpose of creating an exception to the terms of the statute, but for the purpose of better appreciating how those terms would have been understood at the time. We're in number 2, Alito dissenting, Bostock versus Clayton County, Georgia, 2020. The court argues that 2 other decisions, Phillips versus Martin Marietta Corp. And Los Angeles Department of Water and Power versus Manhart, buttress its decision, but those cases merely held that Title VII prohibits employer conduct that plainly constitutes discrimination because of biological sex. In Phillips, The employer treated women with young children less favorably than men with young children. In Manhart, the employer required women to make larger pension contributions than men. It is hard to see how these holdings assist the court. So what Alito's doing is he's going after the precedent that the court used, that the Republicans used. And he's saying, no, they're not analogous in the way that the court says they are. Wrong. Yeah, I mean, Alito's right. The court extracts three lessons from Phillips, Manhart, and Oncali, but none sheds any light on the question before us. The first lesson is that it's irrelevant what an employer might call its discriminatory practice, how others might label it, or what else might motivate it. This lesson is obviously true, but proves nothing. As to the label attached to a practice, has anyone ever thought that the application of a law to a person's conduct depends on how it's labeled? Could a bank robber escape conviction by saying he was engaged in asset enhancement? So if an employer discriminates because of sex, the employer is liable no matter what it calls its conduct. But if the employer's conduct is not sex discrimination, the statute does not apply. Thus, this lesson simply takes us back to the question whether discrimination because of sexual orientation or gender identity is a form of discrimination because of biological sex. For reasons already discussed, see Part 1A, Supra, it is not. How are you guys doing? You doing all right? Hanging in there? It likewise proves nothing of relevance here to note that an employer cannot escape liability by showing that discrimination on a prohibited ground was not its sole motivation. So long as a prohibited ground was a motivating factor, the existence of other motivating factors does not defeat liability. The court makes much of the argument that in Phillips, the employer could have accurately spoken of its policy as one based on motherhood. But motherhood, by definition, is a condition that can be experienced only by women. Wow, how refreshing. How refreshing. So, a policy that distinguishes between motherhood and parenthood is necessarily a policy that draws a sex-based distinction. Makes sense to me. There was sex discrimination in Phillips because women with children were treated disadvantageously compared to men with children. Lesson number two, the plaintiff's sex need not be the sole or primary cause of the employer's adverse action, is similarly unhelpful. The standard of causation in these cases is whether sex is necessarily a motivating factor when an employer discriminates on the basis of sexual orientation or gender identity. But the essential question, whether discrimination because of sexual orientation or gender identity constitutes sexual discrimination, would be the same no matter what causation standard applies. The court's extensive discussion of causation standards is so much smoke. We talked about the problems with the causation standards in previous episodes. Lesson number three. An employer cannot escape liability by demonstrating that it treats males and females comparably as groups is also irrelevant. There, or on page 40 at the top, the slip opinion. There is no dispute that discrimination against an individual employee based on that person's sex cannot be justified on the ground that the employer's treatment of the average employee of that sex is at least as favorable as its treatment of the average employee of the opposite sex. Nor does it matter if an employer discriminates against only a subset of men or women, where the same subset of the opposite sex is treated differently, as in Phillips. That is not the issue here. An employer who discriminates equally on the basis of sexual orientation or gender identity applies the same criterion to every affected individual, regardless of sex. An employer who discriminates equally on the basis of sexual orientation or gender identity applies the same criterion to every affected individual, regardless of sex. Roman numeral 3, A. Because the opinion of the court flies a textualist flag, I have taken pains to show that it cannot be defended on textualist grounds. But even if the court's textualist arguments were stronger, that would not explain today's decision. Whoa. Pay attention here, guys. Pay attention. Oh boy. He's breaking out the big guns here. Roman numeral 3, letter A. Alito dissenting, Bostock versus Clayton County, Georgia, 2020. But even if the court's textualist arguments were stronger, that would not explain today's decision. Many justices of this court, both past and present, have not espoused or practiced a method of statutory interpretation that is limited to the analysis of statutory text. Instead, when there is ambiguity in the terms of a statute, they have found it appropriate to look to other evidence of congressional intent, including legislative history. Ledge history. Oh, no, you didn't. Oh, no, you didn't. So why in these cases are congressional intent and the legislative history of Title VII totally ignored? Any assessment of congressional intent or legislative history seriously undermines the court's interpretations. Ooh. Letter B. Oh, no, you didn't. Letter B. Here we go. We're cruising. As the court explained in General Electric versus Gilbert, 1976, the legislative history of Title VII's prohibition of sex discrimination is brief, but it is nevertheless revealing. The prohibition of sex discrimination was added to Title VII at the last minute on the floor of the House of Representatives by Representative Howard Smith, a chairman of the Rules Committee. Representative Smith had been an ardent opponent of the Civil Rights Bill, and it had been suggested, that he added the prohibition against discrimination on the basis of sex as a poison pill. On this theory, Representative Smith thought that prohibiting employment discrimination against women would be unacceptable to members who might have otherwise voted in favor of the bill, and that the addition of this prohibition might bring about the bill's defeat. But if Representative Smith had been looking for a poison pill, prohibiting discrimination on the basis of sexual orientation or gender identity would have been far more potent. A fortiori. However, neither Representative Smith nor any other member said one word about the possibility that the prohibition of sex discrimination might have that meaning. Instead, all the debate concerned discrimination on the basis of biological sex. I'm ignoring the footnotes, so you can take a look at the footnotes, as always. Representative Smith's motivations are contested, but whatever they were, page 42 at the top, the meaning of the adoption of the prohibition of sex discrimination is clear. It was no accident. It grew out of a long history of women's rights advocacy that had increasingly been gaining mainstream recognition and acceptance, and it marked a landmark achievement in the path toward fully equal rights for women. Discrimination against There's that word again. Gay women and men. I think you mean homosexual. I think you mean homosexuals. By contrast, was not on the table for public debate in those dark pre-Stonewall days. And that was a quotation from somebody on their side, the Democrat side. For those who regard congressional intent as the touchstone of statutory interpretation, the message of Title VII's legislative history cannot be missed. All right. Letter C. I'm going to take a drink of water. How you guys doing? Letter C. Post-enactment events only clarify what was apparent when Title VII was enacted. As noted, bills to add sexual orientation to Title VII's list of prohibited grounds were introduced in every Congress beginning in 1975, and two such bills were before Congress in 1991 when it made major changes in Title VII. At that time, the three courts of appeals to reach the issue had held that Title VII does not prohibit discrimination because of sexual orientation. Two other circuits had endorsed that interpretation in dicta, and no court of appeals has held otherwise. Had held otherwise. Similarly, the three circuits to address the application of Title VII to, I'm going to add so-called transgender persons. I added so-called. Had all rejected the argument that it covered discrimination on this basis. These were also the positions of the EEOC. Remember, the EEOC used to be run by Clarence Thomas. Remember that in the 80s? In enacting substantial changes to Title VII, the 1991 Congress abrogated numerous judicial decisions with which it disagreed. If it also disagreed with the decisions regarding sexual orientation and transgender discrimination, it could have easily overruled those as well, but it did not do so. After 1991, six other courts of appeals reached the issue of sexual orientation and discrimination, and until 2017, every single court of appeals decision understood Title VII's prohibition of discrimination because of sex to mean discrimination because of biological sex. Similarly, the other circuit to formally address whether Title VII applies to claims of discrimination based on transgender status had also rejected the argument, creating unanimous consensus prior to the Sixth Circuit's decision below. There's good footnotes here. Page 44. The court observed that the people are entitled to rely on the law as written without fearing that courts might disregard its plain terms, but it has no qualms about disregarding over 50 years of uniform judicial interpretation of Title VII's plain text. Rather, the court makes the jaw-dropping statement that its decision exemplifies judicial humility. Rather. Yeah, they got that one wrong. Alito, you're right on the money there, bud. Is it humble to maintain not only that Congress did not understand the terms it enacted in 1964, but that all the circuit judges on all the pre-2017 cases could not see what the phrase discrimination because of sex really means? If today's decision is humble, it is sobering to imagine what the court might do if it decided to be bold. Dang. Alito, you have lightning bolts coming out of your pen. Wow. Go put that on a coffee mug. We're in Roman numeral 4. What the court has done today, interpreting discrimination because of sex to encompass discrimination because of sexual orientation or gender identity, is virtually certain to have far-reaching consequences. Over 100 federal statutes prohibits discrimination because of sex. Take a deep breath, guys. The briefs in these cases have called to our attention the potential effects that the court's reasoning may have under some of these laws, but the courts waived those considerations aside. As to Title VII itself, the court dismisses questions about bathrooms, locker rooms, or anything else of the kind. Oh, Lord. And it declines to say anything about other statutes whose terms mirror Title VII's. This is a disaster. This is the woke heritage of this decision. The woke heritage of this decision. See, you have to understand, Alito is going right after the beast. He's going after the beast, man. He's going after the beast. Share this widely. The court's brusque refusal to consider the consequences of its reasoning is irresponsible. If the court had allowed the legislative process to take its course, Congress would have had the opportunity to consider competing interests, and it might have found a way of accommodating at least some of them. In addition, Congress might have crafted special rules for some of the relevant statutes. But by intervening and proclaiming categorically that employment discrimination based on sexual orientation or gender identity is simply a form of discrimination based on sex, the court has greatly impeded and perhaps effectively ended any chance of a bargained legislative resolution. Before issuing today's radical decision, the court should have given some thought to where its decision would lead. As the briefing in these cases has warned, the position that the court now adopts will threaten freedom of religion, freedom of speech, and personal privacy and safety. No one should think that the court's decision represents an unalloyed victory for individual liberty. I will briefly note some of the potential consequences of the court's decision, but I do not claim to provide a comprehensive survey or to suggest how any of these issues should necessarily play out under the court's reasoning. Bathrooms, locker rooms, and other things of that kind. The court may wish to avoid the subject, but it is a matter of concern to many people who are reticent about disrobing or using toilet facilities in the presence of individuals whom they regard as members of the opposite sex. For some, this may simply be a question of modesty, but for others, there is more at stake. For women who have been victimized by sexual assault or abuse, the experience of seeing an unclothed person with the anatomy of a male in a confined and sensitive location, such as bathroom or locker room, can cause serious psychological harm. I'm going to take a drink of water. Under the court's Under the court's decision, however, transgender persons will be able to argue that they are entitled to use a bathroom or locker room that is reserved for persons of the opposite sex with which they identify. And while the court does not define what it means by a transgender person, and listen to that, page 46 at the top. While the court does not define what it means by a transgender person, What could possibly go wrong? I have been hounding that the entire time. That's why I keep saying so-called. The term may apply to individuals who are gender fluid, whatever that means, and we don't know what that means. That is individuals whose gender identity is mixed or changes over time. In other words, somebody who lies or speaks falsely because of a mental issue, who just makes stuff up because they don't care and they just want to cause problems, or someone who is like seriously messed up, somebody who lies. Thus, a person who has not undertaken any, I'm not saying all people are like that. I'm just saying it only takes some. Thus, you gotta ratchet down these definitions. You have to have a definition of these terms. Real consequences are at stake here for federal liability. Thus, a person who has not undertaken any physical transitioning may claim the right to use the bathroom or locker room assigned to the sex with which the individual identifies at that particular time. And for, by the way, for whatever particular reason or no reason at all. The court provides no clue why a transgender person's claim to such bathroom or locker room access might not succeed. A similar issue has arisen under Title IX, which prohibits sex discrimination by any elementary or secondary school and any college or university that receives federal financial assistance. In 2016, a Department of Justice advisory warned that barring a student from a bathroom assigned to individuals of the gender with which the student identifies constitutes unlawful sex discrimination, and some lower court decisions have agreed. Good footnotes as usual, page 47 at the top. Um, Women's sports. Another issue that may come up under both Title VII and Title IX is the right of a transgender individual to participate on a sports team or in an athletic competition previously reserved for members of one biological sex. This issue has already arisen under Title IX, where it threatens to undermine one of that law's major achievements, giving young women an equal opportunity to participate in sports. The effect of the court's reasoning may be to force young women to compete against students who have a very significant biological advantage, including students who have the size and strength of a male but identify as female. That is, they just say they are female. That's all it takes for any reason or no reason at all. And students who are taking male hormones in order to transition from male to female to male, which is a bunch of bull crap. And even if you disagree with me that it's a bunch of bull crap, it could be a bunch of bull crap. It could be. And in some cases, it probably is. There's no objective standard here. That is to say, besides merely what the person says. Then they could be lying. Lying is relevant in employment decisions, and it's also relevant in educational contexts. Well, students in the latter categories have found a success in athletic competitions reserved for females. Good footnotes. Check out the footnotes, page 48 at the top. The logic of the court's decision could even affect professional sports. Under the court's holding that Title VII prohibits employment discrimination because of transgender status, an athlete who has the physique of a man but identifies as a woman could claim the right to play on a woman's professional sports team. The owners of the team might try to claim that biological sex is a bona fide occupational qualification, but the BFOQ exception has been read very narrowly. Housing. The court's decision may lead to Title IX cases against any college that resists assigning students of the opposite biological sex as roommates. A provision of the Title IX, 20 USC 1686, Section 1686 allows schools to maintain separate living facilities for different sexes, but it may be argued that a student's sex is the gender with which the student identifies. Similar claims may be brought under the Fair Housing Act. Employment by religious organizations. Briefs filed by a wide range of religious groups, Christian, Jewish, Muslim, expressed deep concerns that the position now adopted by the court will trigger open conflict with faith-based employment practices of numerous churches, synagogues, mosques, and other religious institutions. They argue that religious organizations need employees who actually live the faith, and that compelling a religious organization to employ individuals whose conduct flouts the tenets of the organization's faith forces the group to communicate an objectionable message. And we've seen that at Biola University. We've seen that all these at Biola and other Christian schools. Mm, this is great. Good stuff. Yeah. Okay. I'm going to take a drink of water. I'll have you look at me for a sec. I mean, I hope that you're getting the point here that this is really important stuff for the woke culture. This problem is perhaps most acute when it comes to the employment of teachers. See the case of Jessica Tapia. I follow her on Instagram. Oh my gosh. A school standards for its faculty communicate a particular way of life to its students. And a violation by the faculty of those precepts may undermine the school's moral teaching. Thus, if a religious school teaches that sex outside marriage and sex reassignment procedures are immoral, the message may be lost if the school employs a teacher who is a same-sex relationship, in a same-sex relationship, or has undergone or is undergoing sex reassignment. Yet today's decision may lead to Title VII claims by such teachers and applicants for employment. At least some teachers and applicants for teaching positions may be blocked from recovering on such claims by the ministerial exception recognized in Hosanna Tabor Evangelical Lutheran Church and School versus EEOC 2012. Two cases now pending before the court. By the way, I mean, remember, this is 2020 and things have developed since then, but it's important to get the snapshot as it was in 2020. Two cases now pending before the court present the question whether teachers who provide religious instruction can be considered ministers. But even if teachers with those responsibilities qualify, what about other very visible school employees who may not qualify for the ministerial exception? Page 50 at the top. Provisions of Title VII provide exemptions for certain religious organizations and schools with respect to the employment of individuals of a particular religion to perform work connected with the carrying on of the activities of the organization or school. But the scope of these provisions is disputed, and as interpreted by some lower courts, they provide only narrow protection. Healthcare. Healthcare benefits may emerge as an intense battleground under the court's holding. Transgender employees have brought suit under Title VII to challenge employer-provided health insurance plans that do not cover costly sex reassignment surgery. Similar claims have been brought under the Affordable Care Act, ACA, which broadly prohibits sex discrimination in the provision of healthcare. What could go wrong? What could go wrong? Page 51 at the top. Such claims present difficult such claims present difficult religious liberty issues because some employers and healthcare providers have strong religious objections to sex reassignment procedures, and therefore requiring them to pay for or to perform these procedures will have a severe impact on their ability to honor their deeply held religious beliefs. This is all very disturbing. I'm hoping you're seeing how disturbing this is. And we don't have very long to go here. So I'm going to get another drink of water. We did healthcare. Um, and we're on page 51 at the top of Alito dissenting and Bostock versus Clayton County, Georgia, 590 U.S. blank 2020. It's a slip opinion. The next section is freedom of speech, but I'm just going to take a pause here and get some water here. Oh man, this is tough stuff, isn't it? It shows you the power of the court, even over cultural matters, because sometimes people don't give a damn and they just go with whatever the flow is. And the court can provide a flow inappropriately in the wrong direction that takes decades to overcome and to reverse. And I'm hoping that we can overcome that, and provide a cultural love for proper textual analysis and constitutional norms. But hey, that's just me. Freedom of speech. The court's decision may even affect the way employers address their employees and the way teachers and school officials address students. We're covering this with St. Benitez's recent decision in December 2025 about the Democratic K through 12 policies requiring school officials to lie to parents, to lie to them, compelling false speech in the name of so-called transgender protection. Bull crap. And Roger Benitez totally nailed it. We've done one episode. We're going to do a couple more in that series. It's going to be in the gender series. Yeah, under established English usage. Sounds pretty good to me. Established English usage. I mean, we are speaking English. Two sets of sex specific singular personal pronouns are used to refer to someone in the third person. He, him, and his for males, she, her, and hers for females. And by the way, who goes around telling people how to refer to them in the third person? In ordinary English usage, the speaker decides based on what is evident to them, the person, whoever it is speaking. It's the discretion of the speaker, not the listener, to decide which words to use. That's always how it's been. That's always the rule. It's not the listener that can make you ignore what you think is true. That's just not how English usage goes, unless you get the courts involved and you have criminal consequences or administrative consequences. It's manipulative. But several different standards of gender neutral pronouns have now been created and are preferred by some individuals who do not identify as falling into either of the two traditional categories. And by the way, this language of identify just means based on what evidence? Based on what they say. But what they say could be a lie. It could be crazy. It could be just their mental illness or mental problems. It could be social problems. It could be a false statement for other reasons than lying. Some jurisdictions, such as New York City, have ordinances making the failure to use an individual's preferred pronoun a punishable offense. Jeez. And some colleges have similar rules. After today's decision, plaintiffs may claim that the failure to use their preferred pronoun violates one of the federal laws prohibiting sex discrimination. The court's decision may also pressure employers to suppress any statements by employees expressing disapproval of same-sex relationships and sex reassignment procedures. Yep, happening at Christian colleges. Thank you, Supreme Court. Not. But you know what? I'm not just upset about the Christian colleges. I'm upset about all the colleges. None of the colleges should have to go by through this bull crap. It's not a particularly religious harm. There shouldn't be exceptions here for religious liberty. This is a problem on public campuses because we're talking about English usage and proper interpretation of statutes. The court's decision may also pressure employers to suppress any statements by employees expressing disapproval of same-sex relationships and sex reassignment procedures. Employers are already imposing such restrictions voluntarily, and after today's decisions, employers will fear that allowing employees to express their religious views on these subjects may give rise to Title VII harassment claims, page 53 at the top. Constitutional claims. Finally, despite the important differences between the 14th Amendment and Title VII, the court's decision may exert a gravitational pull in constitutional cases. Under our precedents, the Equal Protection Clause prohibits sex-based discrimination unless a heightened standard of review is met. By equating discrimination because of sexual orientation or gender identity with discrimination because of sex, the court's decision will be cited as a ground for subjecting all three forms of discrimination to the same exacting standard of review. And I love that he said that. Did you catch how he said it? The court's decision will be cited as a grounds for subjecting all three forms of discrimination. And notice there's not just one form here. The majority is saying there's just one form, but the dissent correctly is saying no, these are three forms. Only one is mentioned in 1964 Civil Rights Act, right? Title VII and its amendments. Under this logic, today's decision may have effects that extend well beyond the domain of federal anti-discrimination statutes. This potential is illustrated by pending and recent lower court cases in which transgender individuals have challenged a variety of federal, state, and local laws and policies on constitutional grounds. Yeah, lots of citations here. I'm skipping the citations. Page 54 at the top. Still citations, citations, citations go through the end of that paragraph. Although the court does not want to think about the consequences of its decision, we will not be able to avoid those issues for long. The entire federal judiciary will be mired for years in disputes about the reach of the court's reasoning. The updating desire to which the court succumbs no doubt arises from humane and generous impulses. Let's go back to this again. We mentioned this earlier in this episode. The updating desire to which the court succumbs. This is a separation of powers point because the dissent is correctly saying the court is properly bound by the judicial power, which implies a judicial duty to say what the law is, to stay in its lane. Okay. And statutory construction is just trying to get at what Congress said. And if it doesn't conflict with the Constitution, okay, that's the law, right? Okay. And if it's the 1964 Civil Rights Act, let's just say it comports with the Constitution. Let's just grant that. Okay. It's not the issue. The issue is not whether it's against the Constitution. It's what it said in 1964 using the language of sex discrimination. And did what it say properly reach so-called transgender status where someone just says they're whatever, and that means they are just whatever? That's a current trend, but is that really properly reflected in the public understanding of those terms in 1964? The dissent is properly saying no. No. And The majority opinion just ignores that. And it seems like the majority opinion just wants to go along with the popular crowd on this issue for some reason. Now, maybe they're humane. Maybe they're just trying to be humane, but that's not legal reasoning in this type of a case. Okay. Today, many Americans know individuals who are gay. I'm gay. I'm very gay. And you know what? We did a whole episode where we interviewed a gay Republican, January 20th, 2025, the year and the date that Trump was re-inaugurated. We interviewed a gay Republican. The episode is called A Gay Republican. And he talks about when he found out he was gay, he was reading the dictionary and he came across the G's and he looked at the definition. It said happy. And he's like, I'm happy. I'm gay. And he said to his wife, I'm gay. And his wife read it and she said, you know what? I'm pretty gay too. And we have a gay marriage because they went to the definition of marriage. It said a union between a man and a woman by which they become husband and wife. It's a sui generis relationship. And they said, we have a gay marriage. But gay does not mean homosexual, right? We have a different word for that. It's called homosexual. Today, many Americans know individuals who are homosexual or so-called transgender and want them to be treated with dignity, consideration, and fairness that everyone deserves. I agree. I completely agree with that. But the authority of this court is limited to saying what the law is. See, this is an issue of separation of powers. Separation of powers. Article 3, judicial power, judicial duty, say what the law is. Congress can change this statute. The role of the court is not to update statutes. The updating desire to which the court succumbs is inappropriate, according to the separation of powers framework that the Constitution establishes. Appropriately establishes because the separation of powers protects individual liberty. The court itself recognizes this. Quote, the place to make new legislation lies in Congress. When it comes to statutory interpretation, our role is limited to applying the law's demands as faithfully as we can in the cases that come before us. Unquote. It is easy to utter such words if only the court would live by them. I respectfully dissent. That's Alito. Alito, and then there's these appendices, and you got to check out the appendices. Oh my gosh, he goes through these definitions, Webster's, sex, one of the two divisions of organisms formed on the distinction of male and female, males or females collectively. Yep, there we go. There we go. That's Webster's. And these are dictionaries at the time of the adoption. That was 1953. So these are reflecting the public understanding. This is epistemological function here. It's evidence. Episteme means knowledge. You can have the knowledge, evidence required by knowledge to from looking at these ways that these terms were defined at the time. And there's Webster's again, 1966, same thing. Oxford English Dictionary, 1933, same thing. Sex is either of two divisions of organic beings distinguished as male and female, respectively. There you go. Okay. I'm scrolling, man. I'm scrolling pretty fast. There's a lot here. There's a lot in the appendices. Concise Oxford Dictionary of the Current English, 1964. Sex, being male or female. There we go. Random House, 1966. Sex, the fact or character of being male or female. American Heritage Dictionary, 1969. Sex, the property or quality by which organisms are classified according to their reproductive functions, either of two divisions designated male and female of this classification. Webster's, again, 2002, sex, one of two divisions of organic, especially human beings, respectively designated as male or female. Um, I'm I'm not even reading all of them, but they all say the same thing. Random House 2001, sex, either the male or female division of the species as differentiated with reference to the reproductive functions. American Heritage Dictionary 2011, same thing. Um, then there's all these statutes that rely on those definitions, and there's a lot of them, a lot. I think there's dozens. I've already scrolled through in this time 5 pages, six now, maybe 100 statutes here, 7, 8, 9 pages. This is no joke, dude. 12 pages, 15. I, I'm I'm not even done yet, and now we have appendices of federal forms, application for enlistment. I filled that one out. Examination for enlistment. What is this? These are different forms. Verification of personal data. Looks like application of some kind. Yeah. So this is pretty consequential, guys. Lots of forms. Lots of forms. Shoot. At least a dozen pages of forms. I'm not even done scrolling, and I'm scrolling about one per second. Okay, now Kavanaugh also has a dissent, which is worth going through and check it out. We will get to it in the next episode. Justice Kavanaugh's dissent. Thanks for joining me on the Republican Professor podcast. I've been your host, Dr. Lucas J. Mather. It is 23 January 2026, years after Jesus. It is a Friday, and I am so happy that you're here listening to these important episodes on the Republican Professor podcast. In fact, I'm so happy I'm going to go have a cigar tonight, and I'll be thinking about you. Lord, thank you for this time. Father, thank you for illuminating our minds to allow us to have knowledge. We're not mere robots. We're not accidentally created. We are created on purpose, and we are created in part to know. We thank you for the opportunities you've given us to learn and to know today. Help us to make good use of them. In Jesus' name, amen. God bless, guys. Take care.